This week on Conspiracy in Canton.
Boston police officer John O'Keefe was found face up in the snow on Saturday morning.
His girlfriend, Karen Reed, has been charged. She's accused of backing into him with her car and leaving him to die in a blizzard outside of a party at a Canton home.
Reed pleaded not guilty to manslaughter, motor vehicle homicide, and leaving the scene of a crash causing death.
Lawyers for the woman under arrest not only say their client is innocent, but they're alleging a cover-up.
They say there were a lot of people at the home that night, and one of them Googled how long to die in the cold hours before Reed would have known O'Keefe was missing.
First got to that scene at 6 a.m. and did not find a single piece of taillight. And then 12 hours later, boom, they found taillight everywhere.
A lot of people are talking about this. This is a small town where everyone knows everyone.
People in this town are scared of the people who are supposed to protect and serve.
Reed's parents and thousands supporting her say there's so much more to this story that doesn't add up.
In the video that the prosecution turned over to us, there is a gap, which would have been the precise time my client would have been driving back past the library. We know that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle.
Filing her defense is asking to subpoena Google for any records of a camera system at 34 Fairview Road. Court documents say Albert told a grand jury he was given a security camera for Christmas but never installed it.
If Brian Albert was asleep during the hours that they're asking for his cell phone evidence, why wouldn't he just turn it over? And why is his phone number changed on the police report?
I don't think there's any kind of conspiracy or anything like that.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
This is not a Hollywood star. This is an accused murderer getting a standing ovation as she enters the courtroom. What is going on out there?
Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed! Free Karen Reed!
Anyone who has spent time watching true crime documentaries or TV shows or paid attention to current trials can tell you that technology is one of the primary ways that law enforcement agencies are able to solve crimes. Location data, surveillance videos, call records, even health apps are all just one subpoena away from providing authorities with a second-by-second timeline of your every move. I've mentioned previously that memories can be unreliable, as can witness testimony, but data doesn't lie. There have been a lot of things that we've talked about so far that have raised some questions throughout the initial phases of this investigation. The inconsistent statements have made putting together the timeline difficult, but these are the things that we can piece together with the information we have from technology of those involved. Or is it? Like everything else with this investigation, there are issues. For example, Ring cameras that face the direction where John's body was found, but are said to have not captured anything. Surveillance video collected from the Canton Library that shows Karen's car heading toward Albert's house, but just happens to be missing 2 minutes of footage at the exact time that she would have passed back by, showing if her taillight was cracked or not. Deleted calls and searches on Jen McCabe's phone, and a request by Trooper Proctor for geofence information to show who was in the house that night, but it conveniently left off iPhones and instead only requested Google or Android information. Now, according to statistics from TechRepublic.com, only about 37% of Americans use Android phones, while more than 62% use iOS. So why would you exclude Apple from a geofence request? But missing footage isn't the only technological hurdle the defense has run into. After multiple requests for phone records for Brian Albert and Jen McCabe's phones, Judge Beverly Cannon has not only denied the request, she even canceled the scheduled evidentiary hearing, denying the defense the opportunity to prove their allegations, even after they flew in an out-of-state forensics expert to testify. There seem to be roadblocks at every corner for the defense when it comes to getting the data and records they're requesting. But they do have some information. Data forensics expert Richard Green with United States Forensics, LLC, or USF, did an analysis of Jen McCabe's iPhone and John O'Keefe's iPhone. Both iPhones, go figure. Using Cellebrite, which is the global leader in digital intelligence investigations, Green was able to extract some information from those phones that gave some pretty interesting information. One of the key findings, Jen McCabe's Google search of how long to die in the cold at 2:27 a.m., hours before she accompanied Karen Reed when she found John O'Keefe's body. This is huge, y'all. Imagine if the Cellebrite report had showed that search came from Karen Reed's phone. It would be the proverbial smoking gun in the Commonwealth's case. But it didn't come from Karen. It came from Jen McCabe, the sister of Nicole Albert, who, you'll remember, lives in the home where John was found with her husband, Boston police officer Brian Albert. Jen's phone also showed deleted calls and a deleted screenshot with her brother-in-law Brian Albert's phone number. That phone number, by the way, is the same one that was removed from the original police report and replaced with a different number, though the date of the report remained the same, as if it had never been changed. What if the defense hadn't received the first copy? And who changes a witness phone number on a police report? And what are they hiding? There's also some location data on Jen's phone, which let us know all of the statements about what time she and the other guests left the Alberts' home that night were not accurate. Then there's John's phone. Health application data gives us information about the steps that John took as well as his location. We also have the video surveillance from Canton Library, which, as I mentioned, just so happens to be missing the two most crucial minutes of the entire footage. But before we get into everything the technology was able to tell us, let's take a moment to look at what they aren't able to see and why. The first forensic download and extraction of Jen McCabe's phone was limited to the analysis of records of communication between Jen and John O'Keefe, Karen Reed, and Carrie Roberts. It did not include her communication with anyone else in the house that night. In a motion filed by Karen Reed's defense team in September of 2022, her attorneys requested the court issue a summons ordering the witnesses to provide cell phones for forensic analysis for a 7-day period spanning from January 28th through February 4th, and that the court issue an order for a complete copy of the Cellebrite extraction from Jen McCabe's phone, as opposed to the limited version that they had received. The witnesses' phones requested included homeowners Brian and Nicole Albert, Jen McCabe's husband Matt, Julie Albert, who is the wife of Selectman Chris Albert, and also their son Colin, who you'll remember Karen says is the only person that John ever had any issues with. Also, Brian Higgins, the ATF agent who was also in the home that night, who supposedly left at 1:30 a.m. after being at the bar all evening to go to Canton Police Department and do clerical work. And then finally, Julie Nagel, who was at the house and called her brother Ryan to come pick her up, but ended up staying after speaking to him outside for a short time. You'll remember Ryan is the witness who told authorities that he saw Karen in her car alone with the interior light on, with no damage to her taillight. In this motion, the defense explains why they want this information. The motion reads, quote, Brian Albert, a highly trained boxer and fighter, has deep familial and personal ties with two other police agencies, the Canton Police Department and the Massachusetts State Police, the very agencies that took control of the investigation into O'Keefe's death. Even more alarmingly, Brian Albert has an intimate and personal relationship with Massachusetts State Police Trooper Michael D. Proctor, the lead investigator assigned to this case. All of the individuals who were present at the home of Brian Albert in the hours before John O'Keefe was found deceased in his yard are related to Brian Albert and or have a close personal relationship with him and his family. Unsurprisingly, Brian Albert has exerted an enormous amount of control over this investigation, going so far as to hold an in-person meeting with the percipient witnesses at his residence in the hours immediately following the discovery of O'Keefe's body, and ensuring that he was in close proximity to them as they were interviewed by the Canton Police Department, where his brother Kevin Albert works as a law enforcement agent. As set forth herein, text messages and calls between and among the individuals who were at the crime scene on the early morning of January 29th, 2022, and in the days that followed, will unquestionably provide necessary and exculpatory details regarding what actually transpired after Miss Reed dropped O'Keefe off at Brian Albert's residence that night. Miss Reed's constitutional right to defend herself against these charges demands that she have access to these critical communications in order to further establish the intimidation, influence, and deception that Brian Albert has injected into this investigation, along with the individuals he has used to do it." End quote. The motion goes on to give specific details about the witnesses and why their phone data is so important. It also mentions Canton Police Officer Mullaney's report that states Brian and Nicole Albert never came outside to interact with anyone at the scene or even speak to officers, but instead, all of the witnesses gathered at the Alberts' house to get their story straight. The motion also points out that Canton Police Department Detective Sergeant Lank, who was not scheduled to work that day, was asked by Sergeant Good to report to the scene for some unknown reason to conduct interviews with the Alberts. He arrived and did what appears to be a group interview with Brian and Nicole Albert and Matt McCabe. In an investigation, witnesses are generally separated and questioned individually, but that didn't happen here. The motion also requested Julie Albert's phone records. Julie testified in front of the grand jury that she went to Brian and Nicole Albert's house that morning about 8:30 a.m. to drop off Dunkin' Donuts for Brian Jr.'s birthday, at which point Brian Albert insisted she come inside and told her that there had been an accident. And that's interesting, considering in a prior statement to Sergeant Buchanan and Sergeant Tully on February 10th, she said that a phone call from Jen McCabe at 4:55 a.m. woke her up. And that's how she, quote, found out about John dying, end quote. Though that call would have been more than an hour before John's body was actually found. This is huge. This isn't just an inconsistent statement on time that's off by an hour or so. These are two completely separate stories, one told to law enforcement and the other to a grand jury under oath. Brian Higgins, who had been at the house that night and left to go to Canton Police Department at 1:30 a.m., told the grand jury that he woke up to a call from Canton's chief of police, though he ignored the call. He did, however, answer a call after that from close buddy Brian Albert, who he had been with the evening before. He says that this is when he was told about John's body being found in Brian and Nicole's yard. So, in the hours following John's body being found, Brian and Nicole Albert, Jen and Matt McCabe, Julie Albert and Brian Higgins all immediately got together at Brian and Nicole's. After the family had met and talked for about half an hour, Jen McCabe called Sergeant Lank personally and asked him to come back. She suddenly recalled some new information that she wasn't sure if they were aware of, and she wanted to change her statement. It was not until this moment, after this off-the-record family meeting, that Jen first told police that she heard Karen say she wondered if she had hit John. Because of all of this, the defense argues that the records requested are evidentiary and relevant. Judge Beverly Canton, however, denied this motion, despite the extensive arguments to support it. Canton claimed that the defense has not met their burden under the law and claimed that this was a, quote, fishing expedition, end quote, in an attempt to get their phones and just see what they were able to find that could help their case. The defense has also had to fight to get the information for the geofence data. In the original geofence warrant, Trooper Proctor requested data currently stored in relation to any devices identified within the set parameter of 34 Fairview Road. Account information, including personal information within the Google My Account screen, and application history to include all apps downloaded from the Google Play Store to any devices set in the parameter were included. Now, the defense realized that this would exclude applications and data downloaded from the Apple App Store. So they emailed Assistant District Attorney Adam Lally, and they asked that the preservation request include all smartphones. Lally responded the next day on May 19th of 2022 with a modified version of the request, though the defense says they didn't receive the automated email acknowledgement of the request from Google. So what this means is that Lally sent them an email back saying, yep, here's the request. I've got it. This requires all cell phones. He emailed it to the defense, but he never sent it to Google. A few weeks later, on June 7th, defense demanded that Lally show them an acknowledgement from Google that the request for all cell phones was turned in. Lally responded to their demand by forwarding them the automatic email from Google, though the defense noted that the date was 3 days before the amended request to include all phones. Lally actually sent them the first email. The assistant district attorney, in response to a demand from defense to show the amended request for all phones was actually turned in to Google, sent an email confirmation to defense that he knew was wrong. Also, the geofence request that Proctor put in was not what was actually requested. Instead of 48 hours to include January 28th and 29th, Trooper Proctor only requested 6.5 hours, between midnight and 6:30 a.m. Something else that Proctor included in the warrant, a note that law enforcement shall review the list and remove any devices that are not relevant to the investigation. For example, devices that were not in the location for a sufficient period of time. And he also requested that the geofence warrant be sent directly to him via email or digital storage media. So what this means is that not only did he ask for very little of what was requested, but he's also having it sent directly to him, and he, the lead investigator who is a close family friend of the Alberts, will be the one to make any decisions as to what is relevant and what is not relevant to the investigation. This is a big problem. That warrant could contain exculpatory evidence that the defense will never see because Trooper Proctor has made himself the sole gatekeeper of anything the warrant returns. The fight for data is still continuing. This is an ongoing uphill battle. The defense has filed a Defendant's Rule 17 motion, which basically means that they are asking the court to command the witness to produce documentary evidence and objects. They want the phone records of Brian Albert and Jen McCabe. The motion for the phone records with Verizon and AT&T was filed April 12th of 2023. The request wanted basic information from his phone: text, voice calls, voicemails, emails, location data, web searches, pictures, and other communications sent and received between January 28th and February 5th. The request also included any information contained on cloud-based accounts and any access codes and passwords that were necessary. The defense team emailed ADA Lally about this motion and specifically said, quote, "Please provide confirmation in writing by tomorrow that you have provided notice to the record holders, namely Brian Albert, Jennifer McCabe, Verizon, and AT&T, as required by law, indicating that our motion will be heard on May 3rd, 2023 at 2 p.m. in Norfolk County Superior Court." Lally responded that he got it. He said, "You're free to do whatever you like as far as witnesses are concerned." And he ended it by saying that he will let them know whether he's going to call any witnesses and or if he plans to dispute the defense expert's findings. Because if he plans to dispute it, the defense will have to arrange for their expert to appear in court. So he says he'll get back to them with these answers as soon as possible. Quote, "So both you and the court can make whatever necessary accommodations to conduct an evidentiary hearing," end quote. So ADA Lally confirms in writing, per their request, the evidentiary hearing, and will let them know if he's going to have witnesses or dispute their expert at that hearing. Now, this email was 1 day after the motion was filed, so April 13th of 2023. The defense didn't hear back from Lally like he said, so they emailed him a few times asking for a response so they could prepare. Finally, on April 27th, Lally responds. He tells the defense that he plans on filing an opposition to their Rule 17 request for both the animal control records for the Albert's dog, Chloe, and, of course, for the cell records for Brian Albert. Lally also says that as far as having the witness come in for the evidentiary hearing, that's up to them, but the court doesn't usually conduct those in the afternoon. They're usually done at 9 a.m., so given the time and expense to fly in the expert, that would be something that they should confirm first. Because of this, the parties decided to schedule an evidentiary hearing on the Rule 17 motion. The court reorganized its schedule to accommodate this request because this evidentiary hearing was necessary. The emails, the opposition from the Commonwealth, and also the supplemental police report all showed that this hearing was necessary. So they made it work with the court schedule. The defense flew in their expert, and they were expecting Trooper Guarino to provide testimony based on Lally's email, as well as their cell expert, Richard Green. So, on May 22nd, 2023, 3 days before the evidentiary hearing, the defense receives Brian Albert's motion to quash the subpoena, as well as one from Jen McCabe's attorney to quash her subpoena. But most surprisingly, included with these motions was a motion from the Commonwealth opposing the evidentiary hearing on Rule 17. Lally was now opposing the hearing that he had already agreed upon. But that's not all. During the May 3rd hearing, Judge Beverly Cannon stated, quote, "As I understand it, the parties have agreed for an evidentiary hearing, and we rearranged our schedule a bit so that we could accommodate you," end quote. The court inquired about how the hearing on this Rule 17 motion would proceed. Specifically, the conversation between Judge Cannon and the attorneys has, on the record, confirmation from the judge that the evidentiary hearing would be happening May 25th to call witnesses and also to argue Rule 17 on that day. The defense, ADA Lally, and Judge Beverly Cannon all agreed on this. So why is Lally now filing an opposition to this hearing that has been discussed and agreed on by everybody, especially when the court schedule had to be rearranged to accommodate it? And he's doing it 3 days before the scheduled event. The defense is obviously not going to be happy about this. The defense states that any objection ADA Lally now has to this hearing going forward should be deemed to have been waived, as he stipulated to the hearing and to the defendant's intention to call witnesses by email, in person, and before the court. Also, the principle is well settled. Case law states, quote, "A party may not disregard a stipulation given by him, nor can he revoke or escape from it at his will. His consent, once made part of the record, binds him until he is relieved from it by judicial action." So the defense's response to this is that the Commonwealth obviously disputes the findings from the forensics expert, Richard Green. Clearly, the evidentiary hearing is necessary because the court is going to have to hear the evidence to decide the issue of Brian Albert's phone and if Rule 17 will apply so that they can get a warrant for his phone data. So the evidentiary hearing with the witnesses, where the defense is planning to argue their Rule 17 motion, is scheduled for May 25th. The first notice that the Commonwealth is opposing this is May 22nd, 3 days before. At that same time, Brian Albert's attorney has emailed the clerk of courts requesting a hearing before this evidentiary hearing in 3 days, and a date is set for May 24th, the day before the evidentiary hearing. On the 24th, the defense filed their opposition to the Commonwealth trying to get out of the evidentiary hearing, stating the case law that they have clearly already agreed to it on record, and Karen's defense detrimentally relied on the agreement of the parties, and they had already spent significant funds at her expense to fly counsel and the expert out to testify. On the 24th, the hearing for the motions to quash the subpoenas for Brian Albert and Jennifer McCabe begins. After hearing arguments on both motions to quash and the argument from Karen Reed's attorneys, Justice Cannon stated, quote, "Mr. Albert's motion to quash is allowed, and Ms. McCabe's motion to quash is also allowed. So where does that leave us?" End quote. The defense said that this leaves us at a point where we still need an evidentiary hearing in this case. The court's reply is as follows, quote, "Okay, so I'm going to address that. So when there was mention previously, any mention of an evidentiary hearing, that was before I heard from the third parties, Ms. McCabe and Mr. Albert. I've now heard from them, and pursuant to Rule 17, as we know, I must, right? The rule is clear. I need to hear from those folks. So now they're objecting to the evidentiary hearing, as is the Commonwealth. And frankly, regardless of whether or not defense counsel and the Commonwealth agreed to an evidentiary hearing, there's no authority for it. And I am not having an evidentiary hearing in this case." End quote. Attorney Yannetti said, of course there's authority for it. But the court, aka Justice Canton, stood her ground and denied it. She said, quote, "No, I am not having an evidentiary hearing in this Rule 17 motion. I rely on the case law. I have also had the opportunity to read Judge Cipher's decision that was attached to the Commonwealth's motion, a decision I know you are all familiar with. So there will not be an evidentiary hearing on the rule motion. I will hear you, even though the Commonwealth says that this is a regurgitation of the first motion. I will hear you on the Rule 17 motion now. So, Mr. Jackson, I'll hear you on your Rule 17 motion." End quote. So not only did the judge approve both motions to quash, she canceled the evidentiary hearing that she herself agreed to on record with the defense and the Commonwealth the day before it was scheduled and after the expert had been flown in. And she refused to discuss it any further. She didn't even give them a chance. Not only that, but she then ordered the defense to argue their Rule 17 motion, arguably one of the most critical arguments in the case to date, a day early. Attorney Alan Jackson argues for the defense.
Your Honor, our request is not a discovery request. Our request is an evidentiary request. That's very different. We are not asking for discovery through the process of seeking Mr. Albert's phone or the phone records associated with Ms. McCabe. We're asking for evidence. Evidence that's material, evidence that's relevant, evidence that's salient to a third-party culpability defense, one that we've already made a good faith showing exists in this case, and this court has already ruled is a relevant and material defense.
ADA Lally argues for the Commonwealth.
So, Your Honor, the Commonwealth requests that the defendant's Rule 17 motion be denied. This isn't a situation where the Commonwealth is afraid of evidence being produced or desperately afraid, as I believe as it was just characterized. It's simply that counsel and the defendant need to comply with the rules and need to actually state actual facts and actual evidence as opposed to the fanciful fact section that's been submitted to the court.
Lally continues on and talks about a brand new expert who looked at the phone data and says, according to her, the search on Jen McCabe's phone at 2:27 a.m. wasn't how long to die in the cold. It was something about basketball. He asked the judge to deny the Rule 17 motion for the defense. Then, the attorney for the defense, Alan Jackson, has a chance to argue again.
The Commonwealth's theory is supported by nearly nothing. Nothing. Everything that we've suggested is supported by the data, the evidence, and the facts. The Commonwealth's theory is supported by conjecture and really bad policing.
Then he addresses the new cell phone expert. This is one of the most important arguments in this entire case. If you have tuned everything else out, please listen to this part.
Almost unbelievably and very troubling as an officer of the court, Mr. Lally provides a brand spanking new expert yesterday. We didn't have any of the information concerning this new expert. Quite frankly, I haven't even committed her name to memory yet. I don't even know it. It's Hyde, Hyde. First time I've ever heard of Jessica Hyde was yesterday while I was on the plane on my way here. That's when we received that information. And lo and behold, Mr. Lally springs that on us today and starts reciting her factual conclusions and opinions. That is wildly inappropriate, wildly unfair. We haven't had an opportunity to look at her report, to review it in detail, to have our expert compare his notes to her report. What I will tell you is that what Mr. Lally said about her report is not quite true. He didn't quite get that right either. What she actually said is why the timestamp is listing the time of 2:27 and 40 seconds in the morning is unknown. Her words, not my words. That's what she said about the timestamp. That her conclusion is the reason for the definitive timestamp is unknown to her. Well, we know why it is, because we've had more time to distill it. There's something, and I'll take this opportunity since Mr. Lally brought it up and try to explain what his theory, an incorrect theory of the timestamp is. I'll take a minute to explain what the actual true facts are. An Apple iPhone has a clock in it. It actually has two internal clocks. One of those internal clocks is run by a program known as Apple COCOA Core Time. The Apple Cocoa Core Time is the number of seconds from January 1st, 2001 until right now. So for instance, if I open my phone, Apple Cocoa Core timestamp just noted the exact moment that I just opened my phone. And it's noted from January 1st, 2001. Right now, actually in 2022, in January of 2022, those numbers of seconds was around 665 million. About 665 million seconds had passed between January 1st at midnight, 2001, to January 29th, around midnight, around 2:27 in the morning, on January 29th, 2022. Why is that important? Because their expert, Mr. Garino, indicated, you can't rely on the timestamp of how long to die in cold, because that's at the exact same time as the Ozark basketball webpage was brought up. So something must have gone wrong. I don't really know what it was, but it must have been something. Well, what we would do, had we had an opportunity to cross-examine Mr. Garino, is perhaps explain to him that which he doesn't know, which is the following. More than one web page can be up and open on a cell phone at any given time. The court knows this. Everybody who owns a cell phone knows this. You can have multiple pages open. One page is sitting on top of the other, and then there are multiple pages behind it. All those pages are still open and potentially running in the program, in the iPhone. The 2:27 how long to die in cold search was nanoseconds, milliseconds, before the Ozark basketball search page came up. How did Apple Cocoa Core Time relate those two events, those two artifacts on the phone? It happened like this. At some point, she searched, used her thumbs. The Apple iPhone doesn't coordinate the timestamp for when she's using her thumbs. People type faster, people type slower. It coordinates when someone exits out of a search. In other words, when you close that web page. She obviously Google searched how long to die in cold. We know that because we found the search. The deletion was not the deletion of the search, it was the deletion of the page. And as soon as that page was deleted, the other page behind it, Ozark basketball, was immediately populated. And when I say immediately, not at the same time, nanoseconds behind it. We actually have the nanoseconds. It's 5 digits beyond the decimal point. We know exactly how that happened and why it happened. And Rick Green, our expert, has verified that, not through one, not through two, but 5 different tools, establishing exactly how long that it took for the Ozark page to populate behind the how long to die in cold page once Jennifer McCabe exited out of that page. So we know that she was Googling how long to die in cold at minimum, 3 hours before John O'Keefe's body was ever found. This is not some anomaly. It's not a question. It's not, as their new expert says, unknown why the Google search took place or the timestamp is what it is at 2:27:40. We actually know. Rick Green knows. His colleagues know. And the scientific community knows.
This argument blew me away. If there was any doubt about the Google search not taking place at 2:27 a.m., that doubt is gone. This case is gaining a lot of attention, and the Google search is one of the pieces of evidence that those on the side of the prosecution have said is debunked, though nobody can really give a clear explanation as to how they know it's debunked. This is the clearest, most concise, and scientific answer. And like I've said before, data doesn't lie. Jackson goes on to argue that there was communication between Jen McCabe and Brian Albert that was deleted, and things don't just delete themselves off of your phone, which is why the information that they are seeking is valid evidentiary evidence. He also talks some about the step data, and we'll get into that a little bit more later. Jackson explains that Brian Albert is intricately involved in this. They aren't just choosing someone randomly to invade their privacy. They are defending someone accused of murder. And they want the evidence from the people who were there. But after hearing both arguments, once again, Judge Canton sides with the prosecution. More than a month later, on June 20th, 2023, Judge Canton issued a blanket ruling denying the Rule 17 motion. She said the defendant has not shown with credible evidence that relevant admissible evidence will be found on Albert's cell phone or in his cell phone records, and the defendant is improperly attempting to use Rule 17 as a vehicle for the exploration of potential evidence. Now, as to Jennifer McCabe's cell phone records, she also denied that. She says this is based on the defendant not providing a sufficient factual basis that the cell phone records may be relevant to her defense, and the defendant is improperly seeking to use Rule 17 as a discovery tool. In doing so, Justice Canton explained that allowing Karen Reed's Rule 17 request intrude on Brian Albert and Jen McCabe's privacy interests in a manner that far outweighs the defendant's desire for materials requested. Now let's talk about the Ring camera footage and surveillance videos. On January 31st, investigators observed video surveillance camera footage from Ring cameras at John O'Keefe's house. They found this footage by looking at the Ring camera app on his phone that was in their custody. There were two cameras connected, one at the front door and one above the garage overlooking the driveway. From 6 p.m. on January 28th to 6 a.m. on January 29th, the cameras observed approximately 15 events between both cameras, including footage of Karen leaving the garage and backing into John's car behind her. On February 1st, troopers secured the interior and exterior surveillance camera footage as well as receipts from Waterfall Bar. The next day, troopers Dunn and Moore got a video footage from the Canton Town Library, and the day after that from Temple Beth Abraham. Now, the video from the library was positioned so that it would have caught Karen's car as it was driving to John's house after leaving the Alberts. But nothing in this case is that simple. The most crucial 2 minutes in that footage is missing.
In the video that the prosecution turned over to us, there is a gap which would have been the precise time my client would have been driving back past the library. We know that that footage would show that my client's taillight was still intact at that point because she never struck John O'Keefe with her vehicle.
Here's the explanation given by Assistant DA Lally.
A person in our office who for Matthew Dunn of the CPAC unit with
because she never struck John O'Keefe with her vehicle. Yet the prosecution has produced a video from the library with that crucial time period missing.
Now, as far as the video was provided to Trooper Matthew Dunn of the CPAC unit with the District Attorney's Office, that was then shared with Ms. Crawford. It was a person in our office who specifically who deals with forensic and surveillance video and type evidence. It was then archived on our system. Recently, we reached out and spoke to the IT director with the town of Canton again. That share link I tried to send to council, email essentially wouldn't go through. We tried to open it, essentially it won't open. So the link expired within 30 days within 60 days, if not 30 days of it being shared with our office, but the exact information that was provided by the town of Canton was archived by Ms. Crawford, was then provided to council at her arraignment in Superior Court, as well as I was able to download it onto a Citrix file, which I then shared with council earlier this week. So what we have as a video, what exists as a video, what we were given as a video for those relevant time frames was placed onto the archived within our system, was then placed onto a disk, and what's on the disk and what's been provided to council is what we received.
So he says the chain of command and then says what he was given, and it just so happens that the library didn't give them those 2 minutes that are the most important. There are also other key moments that are missing from video footage, like the ring footage of Karen's car arriving back to John's house after dropping him off at the Albert's house. The defense filed a motion requesting the complete production of the videos from Ring, noting that the cameras are motion activated, so they should have footage of Karen returning there. So why didn't it? Authorities accessed the footage with John's phone. Was it available when they were looking at it? The motion was filed in November of 2022, and in January of 23, a Zoom video conference was held where the defense heard from Lally for the very first time that he had already executed a warrant to Ring for the footage. He told defense that he would produce it by January 16th, but of course that date came and went, and another motion was filed by the defense for it. There's also camera footage from Karen's parents' house, which is how they know that Karen's car was towed more than an hour earlier than Proctor claimed. The defense has requested access to the Lexus infotainment and telematics system, the safety system, and the airbag control module, as well as GPS data from the snowplows that were used the night of John's death, specifically the one that the plow driver Lucky was driving in front of 34 Fairview Road. Now, in previous reports, Trooper Proctor claimed that the GPS tracking system for the town plows were not working on the night in question. However, defense filed a request to produce records, stating that Lucky said in a recorded interview that he had talked to someone with the FBI who told him that the GPS was working, and that he had driven by Fairview Road at 2:30 a.m. There are some things that can't be recovered on Jen's phone from the forensics download that was done. The records from her cell phone provider would have given that information. Brian Albert was a fellow Boston cop, and John was found dead in his yard, and he didn't come out to talk to the other cops about it. Plus, he had contact with multiple people in his family, who then came over to have a family meeting before talking to police. His records would have given critical information about his involvement in what went on that night. And the geofence data. That would have given information about who else was there that night. But at every turn, the defense is denied. Motion after motion denied, to the point where the defense has actually filed a petition seeking relief and has requested Judge Beverly Cannon recuse herself, which, of course, she also denied. So we know what isn't allowed, but what about what was? That paints a whole new story. Find out next week as we go into part 2 of the technology footprint. My name is Brandi Churchwell from 13th Juror Podcast. This is Conspiracy in Canton, the controversial case of Karen Reed. Please follow, share, and give us a rating. For more information or episode guides, visit our website at 13thjurorpodcast.com.